because everything I'll be saying is almost verbatim inside the notes, and the note is actually more comprehensive. I think about 12 pages or so. So all I need is just your attention, and then you get the notes. So I'll try and share my screen now. Um, okay, great. I hope you can see my screen.
Yes, sir.
Um,
Yes, sir. Yes, sir.
okay,
Yes, sir.
good. So great. Thank you. So I'll start with the story of the Merchant of Venice that I'm sure that some of us have heard or some of us have read. Merchant of Venice is the story where somebody, I think that was Antonio, owed money and went to, or he had some financial difficulties in his business, and they went to take a loan from a notorious money lender. And the money lender said, well, I don't want my money to get missing. So please bring a surety, someone that will stand for you. So if you're not able to pay, the person will pay. And then he brought in this fellow as his surety. So you had three parties: the person that owed money, the money lender, and the surety. And of course, we know the story. At the end of the day, the debtor could not pay. The creditor took him to court to enforce the terms of the guarantee. And the guarantee said he will extract a pound of flesh. And he was about to cut off that pound of flesh actually in court until the court reminded him and say, all you're entitled to is just a pound of flesh and no blood. Very funny story, but that actually shows you how rigid and sometimes how difficult it can be to interpret and to enforce a guarantee. So we start. This is the outline. I will give an introduction. I will explain what amounts to contract of guarantees, explain what amounts to contract of indemnities. How do you construct these undertakings? How do you enforce? I'll move on to a hybrid called demand guarantees. What are the features you look out for? I'll also explain the forms in which demand guarantees can take. Very quickly deal with personal guarantees before we have our conclusion. All right. Now, I'm sure that you have all done love contracts. Now, every contract carries default risk. Every contract, be it contract for the supply of goods, be it contract for road construction, be it contract for services, every contract always has some element of risk, that it will not be performed, that there can be credit risk, there can be political risk. Political risk means there is a change of government and then the new government says something different. And then all the contracts you have made goes to no avail. Now, although the law prescribed remedies for default, again, let your mind go back to the law of contracts. If there is a contract breach, what are the usual remedies? Usual remedies, as you know, are damages. You can sue for damages. You can sue for specific performance. You can sue for quantum merits, and so on and so forth. But commercial parties think more of risk avoidance. meaning they don't even want it to degenerate to a situation whereby you now begin to even talk about going to court. And then you now have to pursue the other party for damages for the next 5 years in court. So commercial parties are often proactive. How can we avoid it? How can we mitigate this risk? So when commercial parties set out or enter into a contract, what is uppermost on their mind is, what are the risks that are involved in this contract? And how can we mitigate this risk so that we don't even have to go to court at all? Or even if we have to go to court, it will be to go to court just for enforcement, but we'll have tried to achieve some leverage before going to court. So we said a guarantee secures the beneficiary of a contractual obligation by allocating the burden of default risk to a third party. I think, let me quickly move to the next slide, which deals with this particularly. So we have two different undertakings. Remember, I said the whole issue of guarantees, you've identified certain risk in your contract. So, for example, there's a road construction contract between Julius Berger and University of Lagos, or even maybe to even construct hostels, more hostels. And from that example, University of Lagos is the employer. They are the one giving out the contract. Julius Berger is the party that is to perform by building the hostel. So Unilag is thinking, we'll have paid these guys some money upfront. What is the risk that they will perform, they will deliver these hostels at the right time? They said within 2 years, they will finish building. What if story enters and 2 years becomes 3 years, 3 years becomes 5 years? Oh yes, we know that Julius Berger has a big name, big reputation, but we are not interested in reputation. There is a default risk. There is a risk that the hostel may not be completed on time. There is a risk, another risk, that it may be completed in time, but not according to due specification. They can do what job. They can do it. There can be shoddy performance. That's another risk. There can be risk that Julius Berger itself can fold up within the 2 years and then leave us hanging. So different risks. And you have to think about how to mitigate each of those risks. So guarantees and indemnities are collateral undertakings issued by a bank or other sureties to secure an obligation in an underlying contract against the risk of default. So the way it works is there are two separate contracts. The major construction contract between Unilag and Julius Berger. That one stands. Then there's what is called an ancillary or collateral contract, a separate contract, albeit connected with the main contract. So there's a collateral contract that is the guarantee instrument. So Unilag will tell Julius Berger and said, go and bring a guarantee to cover the risk that you will not default, to cover the risk that you will perform according to specification, to cover the risk that you will actually not fold up, or if you fold up, maybe through an act of God or so, we have somewhere that we can recourse to get money, to hire another contractor to finish the job for you. I mean, there are different elements of risk that has to be covered. Even political risk, that a new government will come in and just annul the contract completely. That's another element of risk. So we have the major construction contract, the major contract. Then you have a collateral contract that is the contract of guarantee. Now we said the surety or the guarantor's undertaking is issued at the behest of the obligor or the principal in favor of the obligee or the beneficiary. The surety's obligations are usually created by contract. Remember, I told you, the scenario that we're working with, we have Unilag. Unilag is the contract owner or the employer. Now, in the context of the guarantee, you will call Unilag the beneficiary because they are the obligee. Julius Berger is the obligor because they are the one that have the obligation to build the hostel within 2 years. So we have the normal obligor, obligee. The obligee is Unilag, the beneficiary. Obligor is Julius Berger, who have the contractual obligation to deliver hostel within 2 years. Then you now have the third party, that is the guarantor. So the way the guarantee contract is structured is to recognize the principal parties, the three major parties. So the surety, let's say First Bank. So Julius Berger will go and meet First Bank and said, we need to issue a guarantee in favor of University of Lagos that if I default, if I don't perform well, if I fold up, if anything happens, you pay University of Lagos 500 million. So that's the way it goes. So you have the surety, First Bank, you have the principal, Julius Berger, and you have the obligee or the beneficiary, which is University of Lagos. Are we all together so far? Do you have any question?
No, sir. Yes, sir. We're with you, sir.
We are together, sir.
Can I hear you, sir?
Guarantee. So you have two major contracts. The construction contracts between University of Lagos and Julius Berger, and the guarantee contract between First Bank as surety on behalf of Julius Berger, being a surety to pay or to refund the contract sum. But that will all the obligations will now be in the second guarantee contract. So there are two different contracts, although interlinked together: the major construction contract and the guarantee contract. Good. So we said the surety's obligations are usually created by contract and may give rise to primary or secondary liability, depending on the context in which the undertaking was issued and the proper construction of the surety's obligations. Long sentence, but don't worry. In the very next slide, I'll break it down further. But it suffices to note here that the risk to be covered by a guarantee is not limited to monetary debt. Like the first example I gave, the scenario in the Merchant of Venice, that was for a debt. But just to note that you can actually cover any kind of risk. So it goes beyond the risk that somebody will not pay you back your money. There can be the risk of non-delivery of goods, can be risk of defective delivery. There can be other cases of non-performance of agreed terms. Now, let's move on. There is a major difference between a contract of guarantee and a contract of indemnity. Now, what you see is that the name guarantee is a generic name. Oh, you are bringing a surety, someone to stand as surety, someone to stand as a guarantor. That is layman's language. Now, you are lawyers, or at least training to be lawyers. Underneath that generic name, so for example, generic name is food. I want to eat. What do you want to eat? Food. Food is generic name. Under food, you now have different kind of foods. We have protein, you have carbohydrates, you have minerals, we have fruits, blah, blah, blah. So under that generic name guarantee, there are actually two major kinds of undertakings. So one is what we call the guarantee proper, or call it a true guarantee. Then the other one is called an indemnity. So when you hear contract of guarantee, please, you need to dig further to know, is he a guarantee proper or is he an indemnity? The only thing is that for both of them, they use the generic term guarantee. But in the actual sense of it, under that generic name, there are two types or two kinds. One is what we call guarantee proper, or a true guarantee. Then the other one is indemnity. Now, the first one I'm talking about is the guarantee proper. What is a guarantee? A guarantee is a written undertaking made by one person to a second person, promising to be responsible if a third person fails to fulfill a certain obligation. Sorry. Just 2 seconds, please. Thank you. So I said a guarantee is a written undertaking made by one person to a second person to be responsible if a third person fails to fulfill a certain obligation. That's the definition given the
Can anybody hear Dr. Mayomi?
No, sir. We cannot hear him again, sir.
can't hear him again.
I think we've lost him. Let's just wait a bit. Has it gone off? Maybe.
Hello?
Yeah, okay. Dr. Mayomi, good morning. We can now hear you. We lost you for about 2 minutes.
Oh dear, I didn't know.
Yes, we lost you for about 2 minutes. So that was what we were just talking about. So if you could just backtrack a bit so that they
Very
can
well.
what you were trying to say in the last 2 minutes or thereabouts. Thank you.
Very well. Thank you very much, Prof. Welcome back. But can you still see my screen, please?
No.
No, sir.
No, sir.
Wow.
I think you need to reshare the screen.
Okay. Can you now see my screen now?
Yes,
Yes,
sir, we
sir.
can.
Yes, sir, we can.
Excellent. Let me see if I can widen it a bit. Great. So I believe I was here at the points that probably I lost contact. But did you hear my explanations as to the fact that guarantee is a generic phrase, but that under that generic phrase, there are actually two different types. There is the true guarantee or the guarantee proper, and then there is the indemnity. Did you hear the explanations on that?
Yes, they had
Yes,
that.
Yes, we got that, sir.
Yes.
Great. So I'm now proceeding to examine or interrogate the first one, which is a contract of guarantee. And then using the example I've shared earlier about Unilag wants to build a hostel, enter into a construction contract with Julius Berger, and some of the eagle-eyed lawyers in Unilag, like you, raise different kind of issues. How do we cover the risk that we're seeing? Risk of non-performance that they will not deliver it within 2 years, risk of performance that even though they deliver within 2 years, it may not be up to the standards required, risks that the contractor might actually go insolvent within those 2 years, political risk that the government of the day may dislike Unilag and just chase them out of Nigeria. Then what will happen to us? So all those are the risks that you are trying to cover by requesting that Julius Berger should bring a guarantee. Now, so to now superimpose that example inside this definition, we said Julius Berger now goes to First Bank and said First Bank should issue a guarantee on his behalf. Now, look at that definition again. A guarantee is a written undertaking made by First Bank to the University of Lagos, promising to be responsible if, and underline if, Julius Berger fails to fulfill the contractual obligation to deliver a new hostel within 2 years. That's it. Now, there are some features of a true guarantee contract. Number one, it must be in writing. And that's a requirement under Section 4 of the Statutes of Fraud Act 1677. Very long time. In fact, how many of us were alive by then? I'm sure that Prof was alive then. So a true guarantee contract must be in writing. In the notes that I will circulate to you, there are 1 or 2 cases that an oral guarantee contract was sought to be enforced and the court said no. Because Section 4 of the Statutes of Fraud Act expressly states that a contract whereby or undertaking whereby one party promises to be responsible on behalf of a third party must be in writing. The number 2, like I said earlier, the contract of guarantee must be distinct, must be separate from the underlying contract, and must be separately enforceable. In other words, the construction contract between Unilag and Julius Berger is different from the contract between First Bank and Unilag. Oh, they are interlinked, they are interwoven, they are ancillary, the guarantee contract is collateral. Yes, yes, yes. But the truth is, they are separate contracts bearing separate obligations. In the construction contracts, Julius Berger promises a certain set of obligations. In the guarantee contract, it is First Bank that is now promising a different set of obligation, promising to be responsible if Julius Berger fails in the first contract. And that leads me to the third point, that the surety, that is First Bank, only bears a contingent or secondary liability, meaning the liability of First Bank is contingent, or use a simple word, is dependent upon the liability of Julius Berger. So if the liability of Julius Berger in the earlier contract, which is the construction contract, if its liability is not clearly established, then you cannot properly invoke or enforce the obligations of First Bank in the second contingent obligation, which is in the the contract of guarantee of First Bank. And then First Bank's liability, point number 4, is coextensive with the principal debtor's liability. What do you mean by that? So Julius Berger's liability in the construction contract is for 500 million, meaning that liability is the highest that the surety can also be held responsible for. So it is bumper to bumper liability. If Julius Berger is not responsible more than 200 million, for example, maybe it has parts performed the contract, even going towards the end, before the contract was revoked or before something happened. So what is left is only a small part for only 200 or even 100 million. The liability of First Bank will not exceed that. So it is the amount, or it is the extent of the liability of the main contractor or the principal party that determines the liability of the surety. That's why we said the surety's liability is co-extensive. And then lastly, the contract of guarantee always involves 3 parties. The beneficiary, which is University of Lagos, the principal, which is Julius Berger, and the surety, which is First Bank. So although the guarantee is issued by First Bank as a surety, but all the 3 of them will be parties. Because like I said, the liability of First Bank is coextensive with Julius Berger. So in First Bank's guarantee contract, it will link it will drag in Julius Berger, and then in that contract of guarantee, express mention will be made that our guarantee or our liability is coextensive and will not be more than what Julius Berger also will be liable to University of Lagos for. In fact, in some of the guarantee instruments that I've seen, it was drafted in such a way that the guarantor and the principal party were made to be jointly liable. So meaning if the beneficiary, University of Lagos, wishes to enforce that guarantee contract, it has a choice to pick any one of them under the guarantee contract. So, but the word there is all the 3 parties will be parties to the contract. Do you have any question on contract of guarantee before I move on?
No, sir.
None? Okay.
Dr. Mayomi, can I put
Yes.
a question that will be helpful to the students, particularly on the point about the contract of guarantee having to be in writing? Now, in this day and age of information
Yes, please.
technology and development, can we have, would a contract of guarantee be deemed to be in writing if the communication regarding the essential terms of a guarantee were done by WhatsApp or by SMS, for example? Bearing in mind that in 1677, they couldn't have envisaged that.
Obviously. Thank you very much, Prof. Very interesting question. The answer to that is a very straight yes. Because most legislations, even today, recognize most, if not all, of those modes of communication. And probably let me give a very short background to what happened, why the requirement of Section 4. It was found in the Middle Ages that oftentimes to establish and to enforce a contract, it is my word against yours. And I can say, no, you promised me that you will deliver this contract within 2 years. And I bring about 20 witnesses who are all there and who all swore that, yes, we heard you say 20, we heard him say 2 years. And the contractor too brings his own set of 50 witnesses who also all claim to be there and also say, yes, we were there. He didn't promise you 2 years. He said he will only deliver the contract as soon as practicable. In such instances, it is a case of, it's my word against yours. So Section 4 of the Statute of Fraud Act was primarily created to deal with my word against yours. When nothing is written, there is no medium of communication. There is no medium that puts it down, that anybody could see it, even after the protagonists or the principal actors may even assign the contract or even left the scene. So any form of communication that reduces the parties' agreement in an easily discernible, but not fickle, not something that could be changed according to my whim and caprices. Yes. So, for example, emails, most contracts these days are actually being done by emails, or at least a lot of contracts. Let me not use the word most. Emails, even WhatsApp, because WhatsApp is in writing, actually. I've seen cases that WhatsApp was tendered as evidence and acted upon by the courts. It's in writing. It came from, the only argument, if any, will be to establish whether that message was actually authentic or not. So once the medium of communication could be established as being authentic, why not? Facebook, Instagram, once it is there in writing and it could be established that it is the account of the other fellow, it will be enforced. I hope that answers some of your concerns.
Oh, absolutely. Thank you.
Okay, so move on. Now, quickly bear in mind that we said a true guarantee is made by First Bank to Unilag, promising to be responsible if the word is if, it depends, it is contingent. That's why we said the surety only bears a contingent. Contingent means it depends upon the liability of the principal. The obligor holds a primary liability. But what you see in the contract of indemnity, new slide now, is that the surety is directly liable. The surety bears principal liability for a specific measure of loss that the beneficiary may suffer. Once the principal defaults in his obligation, but without any requirement at all to establish the principal debtor's liability. So using our example, Unilag says, yes, you finish construction within 2 years, but most of the fittings are below standards. They accuse Julius Berger of poor performance. Julius Berger says, no, go and look at all the fittings. Prime, they are all, I use proper fittings. All of them were shipped. All of them were imported, blah, blah, blah. If it's a contract of indemnity, Unilag does not have to prove or to establish the fact that the risk had crystallized. Just on their mere allegation that the obligation was not properly performed, Unilag can simply write to First Bank and draw down on the guarantee obligation. In other words, if that guarantee that was issued by First Bank is an indemnity and not a true guarantee, the surety, that is First Bank, has now assumed primary liability to be responsible. So in this instance, Julius Berger has even dropped out completely from the picture, meaning we have only two parties. Remember that a true guarantee will have three parties, but an indemnity has only two parties, just First Bank and University of Lagos. And the way it will be worded will be different. First Bank will just promise that, yes, we refer to the underlying main contract, but they will now say that upon your determination, meaning it is Unilag that is deciding whether or not there was a default, and upon notification to us that Julius Berger has defaulted, we hereby promise to pay. Full stop. Meaning defaults or liability, let me use the word, liability of the surety arises upon either a statement or more or less an allegation that the contract was not properly performed. That is all. The if that you see in guarantee is missing here. It is not if it is established. It is once you say that there is default, I will pay you. So you see in the features, we said an indemnity contract shifts primary liability to the surety, whereas in a true guarantee, primary liability is always on the principal, and it's only when you establish that liability that it now call upon the contingent liability of the surety. But here, for indemnity, primary liability shifts to the surety. Again, the indemnity contract dispenses with that coextensive liability principle. Remember I said, if the main contract, the construction contract is 500 million, if you make a call on it under a true guarantee, remember I said, it may be that the contract is already partially performed, that maybe what is left is just 200 million, and that is the portion you are making a call for. Under an indemnity, the coextensive liability principle is missing. So even though the contract is already partially performed, the beneficiary is actually entitled to make a call for the full amount of 500 million. You can say, isn't that injustice? Well, that is what you said. I mean, that is what you signed for as a surety. That once the beneficiary makes a statement or an allegation that there has been a default and I suffered the full extent of the contract, whether or not that contractual sum has now been reduced, when they are liable. But I should note in passing here that in practice, most banks actually don't leave it open-ended like that. They now try to put in some safeguards to say, if you're making a call, either that there will be some milestone certificates that you bring. Yes, you can just make that allegation to say they haven't performed. We'll pay you. But most banks now try and somewhat cap that coextensive liability, that they want to know how much actually is the amount in dispute. They will pay you that amount without you having to establish whether there's a default. But they won't leave it open-ended for the entire contract sum. And again, for an indemnity, an oral indemnity, surprise, is enforceable, meaning Section 4 of the Statute of Fraud 1677 is inapplicable. Why? Remember that Section 4 of the Statute of Fraud applies to a true guarantee contract. In fact, the way it was written in that Section 4, in fact, I will encourage you to do your research on this. Go and look for the Statute of Fraud and read that Section 4 carefully. It uses the definition of a true contract. It says where one party has promised on behalf of another person, promising to be liable if the other person defaults, then the contract must be in writing. So they've used the definition of a true contract. They've used that if they've imported the principle of contingent liability. So since the contract of indemnity is not contingent, since it is a primary liability, that takes it out of the purview of Section 4. So that means an oral indemnity is enforceable. And there's one very interesting case, Mount Stephen, which you see in your note, in which someone gave an oral indemnity and said it is for a debt. And he said, listen, if Mr. Lagbaja doesn't pay, no, he didn't use the word if. He said, Mr. Lagbaja owes you, but I will pay for him. And they went to court. He didn't deny that he made that statement, but his defense is that it was a true guarantee and that the other party is here to establish that the money was still outstanding. But the contract said no. The statement you made is an indemnity. So the creditor is entitled to recover it from you without having to inquire into the question of whether or not that money had been paid. So that is so if you look at those features, you will see that there is actually a yawning difference, a big world of difference between a contract of indemnity and a contract of guarantee. Although both, like I said, are usually called by that generic name guarantee. But you need to look at the wordings very well. And that takes me to the next slide, which is, how do you know which is which? Is it a guarantee? Is it an indemnity? And we said you have to construct the particular contract. When I say construct, I didn't mean that you start constructing with a block and cement. I'm not talking about that kind of construction. I mean that you need to look at it, put the contract, the WhatsApp, the whatever it is, put it on the table and study it carefully, looking at the factual context. What is the context in which this guarantee or this indemnity, this particular promise was made? What is the commercial purpose? Is it a contingent liability? Is it a primary liability? And then it is the substance the wordings that will be analyzed for you to know whether it's a true guarantee or an indemnity. So the mere fact that there is a big document and then they now tag it indemnity agreement, even though that is the heading, if you construct the wordings and you see that the wordings is clearly a contingent obligation by the surety, saying that I'm only liable if the principal party is liable, then the mere fact that the heading is called indemnity does not matter. It's not the heading, it's not the tag. It is the substance. It is the way it is drafted. And that's why in the case of African Insurance Development Corporation, the Supreme Court held that it is not a tag, it's not the heading, but rather it is the contents of the bond. Now, there is a textbook, Andrews and Millet, Law of Guarantee. Andrews and Millet suggests that the answer to the question, is it a true guarantee? Is it an indemnity? Is that just ask one simple question when you are looking at the instrument. Would the surety be liable irrespective of whether the principal has defaulted? Simple question. Whether or not. So even if there is a good case to say that the principal has not defaulted, but from your construction of the wordings, the surety has simply said, once you make a statement, once you make an allegation to say that he's liable or that he has defaulted, I will pay you. Then that's an indemnity. Will the surety be liable irrespective of whether the principal has defaulted? If the answer is yes, then the surety's liability is primary and the contract is an indemnity and not a guarantee. Now, before I move on to the enforcement, do you have any questions so far? Any questions so far?
We have two hands raised, so you can go ahead, Salami first and then Prince.
All right, sir. Good morning, sir.
Good morning.
Yes, sir. Sir, I just need a bit of clarity. Owing to the background knowledge we have in law of contract, we were told that the contract of guarantee is a tripartite contract. That is the one between the guarantor and the principal, the guarantor. It's just a tripartite contract, and that of the indemnity is a two-way contract. So I just want to clarify, is this still applicable here too?
Thank you very much. So that is the substance of what I've been saying since. If you remember, when I was looking at the features, can you please look at the screen? One of the features of the contract of guarantee is it involves three parties: the beneficiary, the principal, and the surety. And if you remember, when I was explaining it, I said all the three parties must be represented in that true guarantee contract. But when I came to discuss the issue of indemnity, I said that indemnity has only two parties. Why? Because the indemnity contract has shifted primary liability. So there is no secondary liability. So there is no need to bring in the third person. So it's a primary liability between the surety and the beneficiary. The principal party has no participation at all within the context of the indemnity contract. Is that okay?
All right, sir. All right. Thank you, sir. Yes, sir. Clear, sir.
Yes. Yes, please.
Hello, sir.
How are you doing?
I'm fine, sir. So I have two questions, but firstly, I want to clarify something. The indemnity, in an indemnity, is it that the person indemnifying the other is indemnifying for his loss? Like between two of them, I'm now telling you that, okay, whatever loss you incur in this transaction, I'll take care of it.
Yes, answer is yes.
As opposed to a guarantee that is how will I put it now?
So,
Covering
so,
third party's obligation. I just want a clarification.
so both of them actually promises to be responsible. Eh?
Yeah.
The difference is to what extent and how will my how will my liability kick in. So for a guarantee, you have promised as a surety that you'll be responsible. But if it's a true guarantee, your promise to cover that loss will not be activated until it is actually established that there is a loss. That is what true guarantee is saying. First of all, prove the loss against the principal, the real person that should have done it. Once you establish it, okay, then my own liability as a surety will now come into play. But for an indemnity, even if the loss is not clearly established, once the beneficiary says, I have suffered loss, and the two parties are still arguing on it, it can immediately have recourse against the surety and collect the money, even though the loss has not been properly proved. He's saying that once you say so, on your mere say so that you have suffered a loss, I will pay you.
Okay.
Do you now understand it better?
Oh, okay. So the guarantee is for
And
the third party's obligation strictly,
yes,
that you have to prove, okay, that this person had this obligation, he has defaulted, and so we come to you.
yes.
While the indemnity
So
is for loss. So the second party is saying that I've made a loss on this transaction, though. I don't care whether it has materialized or whatever. Just you are the indemnifier indemnifying me. Is that it?
full stop.
Okay.
Full
So now,
stop. Now you've gotten it.
okay. So, sir, for the question, if in a contract of indemnity, the terms kind of cap the liability of the indemnifier to the, I don't know how to put it now, but like if it ties it to the third party's obligation in a way, it looks like an indemnity. Does it, by tying it to the third party's obligation, does it change the essence of the contract immediately?
No, it does not.
Okay.
And the reason why is because the indemnifier is not saying that it won't pay. He's not saying that he's not saying that it disputes the fact that there is a loss. All he's saying is that, okay, so for example, using that illustration that I gave to you, the contract sum between Unilag and Julius Berger is 500 million. Remember. So that 500 million under an indemnity, whether or not Julius Berger has already done half of the work, under an indemnity, Unilag can actually make a claim for the entire contract sum. Again, that's one of the major difference between the true guarantee contract and the indemnity. again, just for you to have a good idea about that, under a true guarantee contract, like I said, the first thing is you have to establish whether there is a loss. You have to establish the quantum of the loss. So all the parties will go into the hostel, go and look at all the fittings, blah, 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 and then discover that actually the loss is just only 50 million. And then First Bank will now pay. Because as at that time, you have now determined the loss, you have determined the quantum. Then under a true guarantee, the bank will now pay. But under an indemnity, you can simply write to the bank and said, Georgia did a very shoddy job. Our quality surveyors have looked at it and they have advised us that I'm liable to claim the entire sum. The bank will pay. Because the issue of the quantum does not come into it at all. Once you made that statement that, pay my money, they will pay. But I'm now saying that in some instances, the surety may be entitled to cap. Not that they are disputing or trying to establish that you are not liable to make a call, but they could simply make some safeguards and said, although you have said it, can you also bring your architect certificate also? But they won't listen to what the principal party is saying. It is, like I said, there are only two parties, the indemnifier and the beneficiary. So the indemnifier may have put one or two safeguards and said, okay, you said that your accountant or your quality surveyor said you're entitled to claim the entire 500. Okay, bring your certificates. Once you bring that certificate, whether it's forged, whether it's genuine, whether it's that certificate is even still being disputed by Julius Baja, they will pay.
Okay, so that means regardless of whether they cap the indemnity to anything, to a fixed figure, to the obligation of the third party, as long as it's an indemnity, it's an indemnity.
Right.
Okay.
Okay. Our time is fast going. Yes, please. Go ahead.
Yeah. Oh, sir, my question is, seeing that the contract of guarantee is tripartite, and is it possible that in the event that the principal debtor under the contract of guarantee proper is unable to pay, can they then bring an action? For instance, if the surety also declines to pay, can the principal debtor bring an action to enforce payment from the surety, not the beneficiary now bringing the action, the principal debtor bringing an action to enforce payment from the surety?
That's a bit strange. I must confess that I haven't seen that before. And I'll give my response now, and I'll also ask Prof to also weigh in on that. My response would be that, you rightly identify that it is a tripartite contract. And in practice, what you see in practice under a true contract of guarantees, both of them have a joint and several liability, meaning that the beneficiary can proceed against the two. So if, from what you say, if the principal party now wants to escape liability and bring an action to compel the surety only to pay, I'm not sure that action will succeed. It will depend. You see, everything depends on your construction. Everything depends on the way it is worded. That's why I said to construe, to enforce this kind of contract, first and foremost, pay attention to the way it is worded. No two guarantee contracts are usually written the same way. Most of the time, they are written in different ways. So if the way it is drafted it is a tripartite contract, and both the surety and the principal party have a joint liability, then really you can't escape it as the principal party to now try and push it only on the surety, because the surety will also push back and said, no, under law, this is a joint liability. But if it is phrased or worded as joint and several, perhaps there is scope for legal room to say, since it is joint and several, you pay. But I must confess that in my experience, I haven't seen that working, because the truth is, at the end of the day, the person that holds the option to call is a beneficiary. So if, unless there is a clause in that contract that says, yes, it is tripartite, but it is understood that only the surety will pay, then in that case, the principal party will be entitled to push it squarely only on the surety. But if there is no such escape clause saying that it's only the surety, or saying that it is a joint and several, I think at the end of the day, it is the beneficiary that will be entitled to choose whether it should sue both of them together or whether it should proceed only against the surety. But again, like I said, I would want Prof to also weigh in here. Prof.
So can I just add another question so that's
Yeah, go on.
Oh, yeah, all right, sir. So for the contract of indemnity, I know it's a two-party contract between the beneficiary and the surety, but can the beneficiary now choose to elect to like bypass the surety and then sue the person who was who the surety stood for?
Yes, the answer is yes. That's why I said, I mean, the very last statement I said earlier, I said at the end of the day, it is the beneficiary that will actually choose who to sue. So it is a tripartite contract, all right. But in practice, it is one person against two. It is the beneficiary on the one hand against the surety and the principal party together on the other hand. So the beneficiary can choose who to sue among the two of them. But then that now takes you back into why do you actually need to have a guarantee? The reason you actually need to have a guarantee is because you as a beneficiary, you have looked at the principal party and you're saying that there are problems with this guy. If this guy becomes insolvent, what do I do? Isn't that the reason why you actually need a surety, someone that is at least looking stronger, someone that can guarantee that obligation that if you don't perform, yes, it is you, the surety, that I will come for. One author said the essence of having a guarantee contract is having two pockets available instead of one. Ordinarily, under your construction contract, you have a right of recourse against the principal party. So if your intention is to sue against the principal party, you don't even need to even go through the contract of guarantee. You could have sued him under your principal contract for being in default. It's because you are saying that if I sue him, it can take a long time. Why not get a more solvent party that I can get my money from easily? That's the reason why you say, go and bring a guarantor. So it will be very, very rare to see a beneficiary proceeding only against the proceeding only against the principal party, because that makes a complete nonsense of why you asked him to bring a surety that is more solvent in the first instance. And that's why I think your first question is actually important, that can the principal party evade and sue the surety and say, surety, you are the only one to come and carry this? I said I haven't seen it done before, but I said yes, why not in principle? However, depending upon the way the obligations were drafted, depending upon the way the liability was couched.
All right, sir.
Does
Thank you very
that
much.
make sense to you?
Yes, sir. Thank you very much, sir.
Let's try and we have just about how many minutes left? Just about 16 minutes. So we have to quickly make progress. So enforcement of surety undertakings. So once the undertaking is construed in accordance with its obligation. So once you have determined, is it a guarantee? Is it an indemnity? Then the enforcement will follow. So for example, if it is construed as a true guarantee, the beneficiary will make a call on the surety's undertaking. Again, bear in mind what the last person said, it is a tripartite contract. So the beneficiary will make a call on the surety's undertaking, but he will need to establish the principal's liability. You need to establish that he had been in default and this is how much it is before it can enforce the surety's obligation. That's why you need him there as a third person. That's why it is tripartite, because you can't determine that issue of liability behind him. However, if the undertaking is construed as an indemnity, the beneficiary only needs to make a call. You know, it is just two ways, just between the beneficiary and the surety. The principal party is not even a party to that contract. So you only just sue on that contract. Simple. It's between me and you only now. So just make a call on it, and you don't even have to establish the principal's true liability. Don't say that he has defaulted, and I hereby make a call for whatever amount of money that you want. But one quick question there. So going back to our example, if the contract sum is 500 million, and Julius Berger has already performed the contract halfway before the contract was terminated. I mean the construction contract. And the surety undertaking is an indemnity from First Bank. Indemnity. And Unilag make a call for the entire 500 million. And there is no edge around it. Will the bank pay the entire 500 million? The answer is yes. The bank will pay the entire 500 million, despite the fact that the true scope of liability is halfway, 250 million. So the bank will pay, and that's the end of the surety contract because the obligation has been discharged. However, Julius Berger will still have a right under the construction contract to ask University of Lagos to come and account for the remaining 250 because the work was already done halfway. But so that means the parties are now back to the main contract. For that claim can now come in the form of unjust enrichment, etc., etc., etc. But as far as the guarantee as far as the indemnity is concerned, that obligation has been discharged, that contract has been discharged. But it's not as if the beneficiary will just cash in and then you just keep quiet and just chop the money. No. Under the principal construction contract, the principal will still have the ability to make the beneficiary account for the money that is collected under the guarantee contract and which is actually above the true amount of liability that he should have paid. Now, let's quickly move on. Now, there is sometimes you'll be hearing this phrase, demand guarantee. Now, what's a demand guarantee? A demand guarantee, just know is that it is an indemnity, full stop. Why? Sometimes they also call it bank guarantee. A demand guarantee or a bank guarantee is an absolute indemnity, usually issued by a bank or an insurance company to pay a stated sum of money to the named beneficiary once the terms of the guarantee is complied with. Again, like we said, there are only two parties. Just the surety or the indemnifier and the beneficiary. Just two. So it's an absolute promise made by the bank. The way they usually write it is, upon, they will say, we hereby undertake to pay the sum of X amount upon your first demand or upon your written demand that Unilag is in default. Full stop. That's why they call it demand, meaning it is payable upon demand. In fact, that's the way they write it there, that will pay you upon your demand. So that means once there's a demand, they will pay you full. Whether the amount is fully entitled to it, whether they have already made some work, whether it's only quota that is payable, they'll pay you upon demand. Features. The demand guarantee is autonomous of the construction contract. Like I said, there are two separate contracts. Again, there is this school of thought that said it is as good as cash. If you have a demand guarantee in your hands, it's almost like a blank check, as good as cash. Once a demand is made on it, the bank must pay. MUST, must pay. And again, whether or not there is a dispute between the underlying parties, the bank must pay now, and then all the parties can argue later. That's what they call it, pay now, argue later. And there's this English case in which the court coined that phrase, pay now, argue later. And that's the case of Edward Owen and Barclays Bank Limited. I think it's a 1978 case, very old case. Now, in this case, Edward Owen was a company then in the UK, and it had a transaction with a foreign counterpart, I think in Libya. And the transaction is that, we'll supply you with some greenery. You know this greenery, people that are into agriculture will supply you with some raw materials, products, etc., etc. And the Libyan party said, Edward Owen, you as a supply. So there was the main supply contract signed, sealed, and delivered. The Libyan party said, bring a demand guarantee because we are going to pay you some of the money up front to mobilize you. So the Libyan party was to pay some mobilization fee up front. They now said, we don't want our money to go into voicemail. So bring a demand guarantee from the bank that this money that we are going to pay you up front, if you don't perform the contract well, we'll be able to make a demand and we'll get the money upon simple demand. In Edward Owen's bid to secure the contract, it quickly rushed to the bank, got the bank to issue a demand guarantee in the name of the Libyan counterparty, handed over the guarantee, that demand guarantee, to the Libyan counterparty, and it was payable upon demand. So Edward Owen now said, oh yeah, give us the advance money so that we can start the work. Libyan party said, start the work first. So there was a stalemate. Libyan party said, start the work first, then we'll give you the money. Edward Owen said, no, our contract is that you pay the advance fee, then I'll start the work. I mean, that's the reason why I've given you a guarantee that if I don't do the work, you can make a demand. Next thing, the Libyan party made a demand, accusing Edward Owen of not performing the contract. Edward Owen quickly rushed to the courts to block the bank through an injunction from paying. The court first gave an injunction saying, the fault is from the Libyan party now. You didn't mobilize them. The next thing, you are already making a call on the demand guarantee. The case went on appeal. And the English Court of Appeal, then presided over by the late Lord Denning, said, we sympathize with you, Edward Owen. You are right. But that instrument was issued by the bank. Remember, it's an indemnity. There are only two parties. It was issued by Barclays Bank in favor of the Libyan party. Meaning that even you, Edward Owen, you are a stranger to that demand guarantee. You cannot halt it. You cannot stop it. So once the Libyan party has made a demand, the bank must pay. And then the court said the meaning of demand guarantee is pay now, then go and argue later. And that's how that expression came in. So once it's a demand guarantee, you pay, and then you go and argue later. Now, there are different forms of demand guarantees. And I'll have to hurry now. We have just about 5 minutes left. There are about 4 different types, depending on the commercial purpose. There's what's called a bid or tender guarantee, advance payment guarantee, performance guarantee, and retention guarantee. Again, please listen well. That's why I said they use generic name for all these things. All these forms of bank guarantee, they are all, in the actual sense of it, they are all indemnities. But because they call them advance payment guarantee, performance guarantee, they're just using the generic name. In the actual sense of it, in practice, 99% of the time, all these forms of guarantee are all indemnities. So using our Unilag project. So Unilag made a bid and there were different contractors. So there was like an open bid. So Jolobaja came, RCC came, Chagori Brother, different kind of contractors. But what you see is that some of those contractors, at the time they want to get the contract, they will quote low price for you so that they will be able to win the bid. Then after they now win the bid, they will now jack up the price. So to ensure that the price at which that they quoted for you during the bid, that they will continue to maintain it, you ask them to submit a bid or a tender guarantee. That is, this price that you've quoted for me is this. If you win the bid, if you go through the tender process and you win, that is the same price that you will perform the contract. If you change the price, I'll go and make a demand. And usually it's for a hefty sum of money. They can say maybe 10 million. So if after winning the bid, Jobega now came back and said, do you know what? There's an error in our bid process. It's actually 600 million. Unilag will simply just terminate the process and still make a call on this demand guarantee, which is to fix the price. What is an advance payment guarantee? Advance payments simply means what it says. If you are paid some monies in advance, like the example we gave about the Edward Owen case, the person that mobilized you wants to be sure that you won't use his money on something else. You won't divert the money. So at the time of paying you the mobilization fee, you as the contractor, you bring an advance payment guarantee from your bank to cover that amount of money. They call it APG, advance payment guarantee. What about the risk that the contract will not be performed according to specification? The contractor will bring a performance guarantee that if I promise that I will use this quality of material, I will now change it midway and use an inferior material. You cover that risk by way of a performance guarantee. If they go to use an inferior material, the owner of the job will make a call. Remember, all these are forms of demand guarantee. Make a call upon simple demand, the money will be paid. And then retention guarantee is at the end of the contract period. Sometimes, or even in most instances, so Chilobaja finishes the work under 2 years, as they are promised. But the owner of the contract, Unilag, wants to be sure that that contract will stand the test of time. Usually there is an amount of money that they withhold. They won't pay all the money at the end. They usually withhold about 5% for about 6 months to be sure that if there is any complaint or so, you come back and you fix the complaints. That is the retention, or that's the retention period. So you can say, well, instead of you just withholding that 5%, pay it to me. I know the work I have done. Instead, I will give you a bank guarantee that if I don't come back and fix the error, you just go to my bank and just make a claim upon that guarantee. So, and all these guarantees are independent of each other. So at the outset of the project, you submit your bid or your tender guarantee. If you are ultimately successful, that one falls away. Then you now submit advance payment and performance guarantee, which will be operative during the lifetime of the contract. And towards the end, when these two guarantees are now falling away because you used advance payment for what you're supposed to use it for, you perform the contract excellently well. Towards the end, when they're supposed to withhold that 5%, then you now bring the retention guarantee, then they'll give you that 5% money. And if at the end of the 6 months there is no error, then that guarantee will also become odious. It will also be cancelled. And that takes us to the last slide, which has to do with personal guarantees. Personal guarantees is a guarantee issued by a person and not a bank or an insurance company. So, for example, a company director, companies are liable for his own debts, not the directors. But sometimes the counterparty can say, oh, your company is not that solvent. I don't want to deal with the company. I want to deal with the owners of the company. So you, as a company director, give your own personal guarantee that if your company does not perform this contract, you will be personally held liable. Now, in the absence of express wordings, I said guarantees must be construed according to their wordings. It's according to how the parties have actually worded it. In the absence of wordings to the contrary, a personal guarantee is usually construed as a true guarantee, meaning it will be by way of a tripartite contract. The company, which is the principal, the guarantor, who is probably the company director, supporting what the company has said, and then the beneficiary, which is the counterparty. However, again, like I said, it will depend on the way that it is worded. So where a personal guarantee, if you read it properly, and it demonstrates that the way it is worded, that that person that issued it has agreed to pay upon simple demand, then the legal presumption that only bank guarantees can be construed as a primary obligation will be displaced, meaning that a personal guarantee can, if the wording supports it, can be constructed as an indemnity and not a true guarantee. But in the absence of such wordings, normally the law usually makes a presumption that a personal guarantee is not an indemnity. Normally, it will be construed as a true guarantee. Conclusion: guarantees and indemnities are undertakings which secure the risk of default. The whole essence is you have identified some risk that you are trying to mitigate, and that's why you ask for that guarantee. but liability accrues differently. While a true guarantee engages contingent liability, an indemnity engages primary liability. And that difference may be crucial where the creditor is concerned with speed, solvency, scope of protective cover. So if you want to quickly get the money, actually what you should ask for is an indemnity so that the bank or whoever can pay you immediately upon demand. But it will depend on your negotiation power. It depends on the leverage that you have in your contract. So I think we can leave it at this point. Thank you so much for being an attentive class. Thank you for the questions you've raised. Once again, good morning to you. That'll be all.
Thank you so much, Dr. Mayomi. We appreciate your time, even though I can see that. Oh, okay. Yeah, I see that there is probably one hand that wants to ask a quick question before I wrap up. And thank you so much for taking out time to give us a sort of whirlwind exposition on an area of law that appears simple but is quite complex. This is demonstrated by the way and manner in which Nigerian courts have dealt with some of these issues, which you've spoken about. It's a pity that we don't have more time for you to really not only interrogate these issues, but unpack them for us. But at least I'm sure that the class has been well informed. Salam, is there any question that you really want to ask or?
Yes, sir. Good morning, sir.
Good morning.
Sir, I'm curious because we'll be talking about contract of indemnity and guarantee since I'm just curious as to what are the requirements needed most times in the bank for the contract of indemnity or guarantee, because I can't just imagine going to bank now and telling the bank I need guarantee or indemnity for a project, and is it just done in that simple manner, or that's what I'm just curious to, sir.
Dr. Miami, do you want to just quickly jump in? It's more of a commercial question, but I mean.
Yeah, very quickly. So you as so again, using the example that we've been working with since. So the contract owner, that's University of Lagos, ask for an indemnity. And you go to the bank and say, please, I need an APG, that's advance payment guarantee, and it must be worded as an indemnity, payable upon demand. What you have asked the bank to do is to expose itself on your behalf. No bank will do that without taking security from you. So the bank will also ask you as a contractor to also bring your own security. In fact, in most instances, before the bank issues that APG or whatever for you, the bank will have opened a loan account for you. So the bank treats that money as a loan, although it will not run. The minute a call is made on that guarantee, the bank activates your security. Maybe you have deposited some title documents, or maybe the proceeds of the contract is being paid into the bank. The minute a call is made by the beneficiary, the bank activates the security that you've deposited, and immediately the bank treats the money to you as if it were a loan. And then all the necessary incidents of a loan will now follow after that. Thank you.
Thank you very much, Dr. Abayami. So essentially, Salami, banks are not Father Christmas. They would not issue guarantees without having security to support it. And if you don't give that security, you will not get the guarantee from the bank. So almost invariably, you might have to go and bring your father's C of O or the title documents to your uncle's Rolls Royce to be able to get 100 million naira loan and stuff like that. So, Dr. Miami, thank you so much for your time. I'm sure that the class are better informed, not only about the broad concepts undergirding guarantees, but most importantly, the nuance between a guarantee so-called and a contract of indemnity. And obviously, even from Salami's concern and question, it is clear that they understand the true implications of an indemnity, and your explanation of the on-demand guarantee, the pay now and ask questions later within the context of the separate indemnity contract, and still obligations under the underlying contractual relationship between the parties. So thank you very much for, as I said, unpacking this quite complex area of commercial transactions and banking law, as it were.
Thank you very much, Prof.
Yes.
Thank you very much, Prof. I should tell the class that Prof supervised my doctoral thesis on this. So any expertise that I can claim today, I should pay tributes to Prof. Prof did a very excellent job in supervising me, and I remain always grateful to Prof. Thank you very much, sir.
Thank you very much, Dr.
As I told the class, I will forward the notes to you, Prof. I have some notes which I'll forward to you in the next few minutes to be disseminated to the class. Once again, thank you very much for inviting me. I'm grateful, sir.
Okay, thank you very much, Dr. Wami. I think all the hands that are going up, well, they are going down. So I guess, I mean, we can release you. You see that they don't want to release you. In fact, maybe they are trying to say that you should come back and still do another wrap up on this topic, because today was a whirlwind. And I don't know whether at the early point, you took them through the different kinds of guarantees, the APG, the performance guarantee, and all those points.
Well, that was towards the end. Probably just before the exam, I would spare the time to come for like a what do you call it, like a tutorial, if they're interested.
I mean, that would be helpful, because I think that I'll be happy if you can further explain and expatiate on the different kinds of guarantees, the different needs for those guarantees, and the liability regimes under those different guarantees. You know, particularly the advance payments and the special rules around the advance payment in the context of construction contracts, you know, for them to understand performance guarantees as well. And something that you touched on in terms of, even though it was in the context of the indemnity, but also in the context of guarantees generally, that typically what you see in practice is that the wordings of the guarantees are such that as the work progresses, the liability under the guarantee reduces, as it were, you know, all those little points, so that they are very, very clear about the nuances in this area. But thank you very much, Dr. Obayemi. We really appreciate you. And
thank you very much, sir.
Thank you. We're most grateful.
Bye, sir. Bye, class.
Bye.
Thank you very much, sir.
Just before everybody signs off, tomorrow's class is at 11, I believe.
Yes, sir.
Yes, sir.
Okay, I will come back to the class rep whether we would hold tomorrow's class at 11 or we reconvene next Thursday for the normal times. So I'll let the class rep know either later today or very early tomorrow morning. So thank you very much, everybody, and have a good afternoon or good morning still.
All right. Thank you, sir.